All right, good morning. This is the video lecture on Chapter 4 of the Samaha Criminal Law book. The topic for this chapter is really focused on mens rea, and the first thing to understand about mens rea is that it is Latin for an evil mind. And so what we really care about here is the defendant's criminal intent, what is going on in their brain, which makes this really difficult to show in court. The only direct evidence we have of a defendant's intent is if they confess to a crime. We don't always have a confession, so that can make it pretty challenging. Every state uses their own definitions. Mens rea encompasses everything from negligence to premeditated and deliberate homicides. We might have different mens rea for each element of a crime. So each crime could have more than one mens rea. And so prosecutors are frequently looking at how somebody committed a crime to establish mens rea. And then we'll go ahead and note that motive and intent are not quite the same thing. Motive is why you did it. So maybe you wanted to get money, you wanted to get drugs, you wanted to get rid of this person, but your intent is maybe to commit the crime, to get the drugs, to get the money. So they're not quite the same thing, but we can use motive to help demonstrate that intent exists, okay? So we rely on the circumstantial evidence of motive, of how you committed the crime, where did you shoot them, why were you carrying a knife here, did you intend to use it by carrying it? Those types of questions are what prosecutors are looking at. And so under criminal intent, we have three different types of fault. We have subjective fault. Subjective fault is bad mind. You yourself have a bad mind. Objective fault is kind of where we as a society just kind of attribute that to you. We don't require you to have a bad mind. If you kind of engage in the action, then you're liable for what you did. Whereas strict liability has no intent tied to it. If you commit the action in the attendant circumstance, then you are guilty of the crime. So if you operate a vehicle while intoxicated, then you are guilty of an OVI. We don't look at, did you know that you were drunk? Did you want to drive drunk? Those questions are outside of the scope of the statute. Lastly, there's two different types of intent in criminal law. We have general intent and specific intent. So general intent is the intent to commit the act. So to give you kind of a simple example that I think is really effective is I have three little kids at home. I have a 7-year-old boy, a 4-year-old boy, and a 3-year-old daughter. My two boys in particular, but my daughter as well, will pick up like a toy sword or a lightsaber, a water gun, and just start swinging it around, and before you know it, they smack one of their siblings in the face, and sometimes they've even smacked their siblings so hard we've got a black eye or we've got a bloody nose. And so as the parent, my question is, did you mean to give your brother a black eye? No, they're getting punished because they shouldn't have been swinging that toy around in a way that someone else can get hurt. So general intent works like that. If you did the action, you're responsible for the harm. While specific intent means that you wanted to commit the action, plus you wanted to cause the harmful act. So for specific intent, it would be like one of my kids swinging that lightsaber around with the purpose of giving their sibling a bloody nose. They wanted to swing that lightsaber around, and their goal was to give their sibling a bloody nose. That's specific intent. A more criminal example would be driving your car 20 or 30 miles over the speed limit and hitting somebody else. We don't is a more criminal example of general intent. We don't ask that you wanted to kill somebody to make it specific intent. So the first case in this chapter, State v. Fleck, is dealing with this idea of whether their assault statute in Minnesota is general or specific intent. And the Minnesota Supreme Court rules that assault is a general intent crime. If you engage in the assault, we don't necessarily ask, did you have the intent? Okay. So now we're going to talk a little bit about the Model Penal Code levels of culpability. Under the Model Penal Code, there are 4 levels of culpability. They are from most severe to least severe: purposely, knowingly, recklessly, and negligently. These types of mens rea kind of tend to go with certain types of crime. Purposely is the most blameworthy mental state. You want to engage in this crime, you want to cause the act. While knowingly is that you are kind of aware of what's going to happen, or you're practically certain that outcome will happen. Recklessly is a little bit, recklessly is that you know you're creating a risk of harm to others, but you don't intend or expect or care if the harm happens. So you're creating a substantial and unjustifiable risk. You're engaging kind of in this gross deviation of expected behavior. And the last one, negligently, is where you unconsciously create a criminal risk. You didn't necessarily mean to do it, but you should have known better. So if you're driving, 60 in a residential neighborhood, even if you had not driven by a speed limit sign, you don't actually know. You should have known better than driving that fast in a neighborhood. Okay? And so your book has quite a few cases to kind of help parse out what these terms mean. For the case for purposely deals with, did the defendant purposely expose his victims to HIV? It comes from Washington State in the 90s. Calvin Stark had multiple HIV tests. He had been counseled about how to engage in safe sex. He did not do so, and he was convicted of purposely trying to spread HIV. So yeah. The next case in the book is State v. Jancy, and this is a debate between whether it was Jancy's actions were knowingly or reckless. So the court is trying to decide what was his mens rea here. Was it reckless or was it knowingly? He was convicted of assault, and he went to a house with his friend Diane, who they went to her ex-husband's house to pick some stuff up. While they were arguing, Jancy let some air out of the tires. The ex-husband saw him and gave chase. He used a knife to let those air, and so he starts running away. He's still holding the knife. He tries to jump behind some bushes and hide from the ex-husband. The ex-husband sees him and jumps on top of him. And during that scuffle, the landing, the scuffle, the shuffling around, the ex-husband gets stabbed by Pete. And the question is, what was Pete's intent? And the statute says that knowingly or with knowledge is when respect to conduct or a circumstance described by a statute, a person acts with an awareness that his conduct is of a nature so described or circumstances so described exists. They're practically certain that their behavior will cause this harm. The trial court at the end of Jancy's trial said the defendant was letting air out of the tire. He has an open knife. He's aware of what this knife is like. He's aware that it's a dangerous weapon. He runs up the bicycle path. He has a very firm grip on his knife by his own admission. He knows that knife is dangerous. It is not necessary to prove that he purposely thrusted that knife or intentionally thrusted or knowingly thrusted that knife. Quite frankly, all of this could have been avoided if he had gotten rid of the knife. So he knowingly caused physical injury. So the court here overturns that. They said that exact definition is recklessness. The defendant knew he had a weapon and a confrontation could have occurred. He knew it was possible, but what he really did here was aware that he had created this risk and then disregarded the fact that he had created this risk. So that's kind of a classic definition of recklessness. I really encourage you to kind of read through that case. The next case is also kind of differentiating between the two mens reas. recklessly or negligently. Greg Coppersmith and his wife got into a fight. They were arguing and she tried to go in the house. He kind of got in her way. He didn't let her. She tried to go again. He shoved her. She fell off the porch and hit her head on a brick and died. After she landed, though, he wasn't aware that she had hit her head on the brick. He kind of jumped on top of her, started shaking her around. And the question is, was this behavior reckless or was it negligent? And he was convicted of reckless manslaughter, but the Supreme Court reversed it and remanded it, finding that his behavior was actually negligent. He created a risk. He should have known better, but he did not, and that's negligence. Okay. The next chunk of this book kind of looks over some strict liability offenses. A really classic strict liability offense is an open container of alcohol in a vehicle, and so you kind of have a case looking at that. Now the rest of this chapter is focused more on this idea of, we have a couple brief paragraphs on concurrence. This is the idea that the mental fault has to trigger the action, so we need the mens rea first. But the rest of this chapter is focused on causation. So there's two types of causation. There's factual cause or but-for cause. So but for your actions, the result wouldn't have occurred. But for your pulling the trigger, the gunshot, this person would not have died. While legal cause is more kind of fairness, or did we have anything that may have intervened? So if someone pulled that trigger and someone got a gunshot wound that kind of grazed their arm, they wouldn't have died. If they go to the hospital and the hospital staff doesn't follow procedure or is too invasive and the person dies of the injuries from the surgery or the hospital's interventions, well, now we have kind of an intervening cause. So under this idea of proximate cause, we would ask, is it fair the defendant be responsible for this actions? And so your case has an assault, your book has an assault case kind of exploring this kind of consequence, whether or not Bauer caused gunshot wounds, and we're kind of dealing with a teacher seeing a child with blood on their hands. She realizes what's going on. The child had been shot. Another child had brought a gun to school in their backpack, and it had discharged. Police are interviewing this juvenile. She was at her mom and boyfriend's house. She took the gun because they were not keeping them locked up. And so the question is, did the person who let this child have access to the gun by not following safe practices, should he be responsible? And the court says no. They reversed his decision. He kind of the subjective idea of fairness. There are some intervening actions, the child's behaviors. He didn't have knowledge, he didn't get permission, okay? I only have a couple more minutes before my video will stop, so we're going to just run really quickly. There are also some failure of proof defenses, most importantly, ignorance and mistake to look over. In general, ignorance of the law is not an excuse. But a mistake of fact is a defense when that mistake means you cannot form mens rea, when you cannot get to these ideas of purposely, knowingly, recklessly, or negligently that are still up here because it's just so important. So if a mistake of fact means you can't form that intent, then you cannot be held liable for that. There is a case to help explain it. I definitely encourage you to look it over and let me know if you have any questions. This topic is really important, and we're going to be talking about mens rea over and over throughout this semester. So please feel free to reach out and let me know if you have any questions. I look forward to hearing from you and working with you on these topics. Have a good day.